Not every case would meet appropriate fairness or need standards. People going through divorces tend to rely on friends or family that have maybe been through divorces. So it's not something that automatically happens in every single case.
Hello and welcome, everyone. I have with me today attorney Bailey Holt. Bailey Holt is a senior associate at Sterling Law Offices. She's been with us now for going on 3 years, Bailey?
Yeah, 2.5 years. I graduated 3 years ago from May.
And you have just been an exceptional, outstanding attorney at the office. I love working with you. I learn something from you on a pretty regular basis. That's why I've invited you to come and talk about probably the most frequently asked question, I would say, with clients, which is maintenance. Who gets it and why? And so, whenever we are meeting with new clients, one of the questions we hear in a consultation is, am I going to have to pay them, or will I be able to get support for myself? And in Wisconsin, we call that maintenance or spousal support. So I would love to hear, and I know our audience would love to hear more about determination factors and figuring out what they can reasonably expect to be paid or to pay. So what I'd like to know is, we hear the word maintenance, we hear the word alimony, we hear spousal support. What's the difference?
They all mean the same thing. Wisconsin calls it maintenance, but maintenance and alimony and spousal support, they could all be used interchangeably, but you will hear maintenance used as the primary term in Wisconsin.
Got it. So people use, I mean, they may use the word alimony, and at the end of the day, maybe it's not the legal term that we're using in Wisconsin, but it's one and the same thing.
Yeah, that's correct. Yep, they all mean the same thing.
And is there maintenance in every single divorce or legal separation in Wisconsin?
No, there's not. It's maintenance is we always say it's like the biggest gray area in family law. It's very factor and case specific. So the court will consider many factors when determining if maintenance should be paid, and not every case would meet like what the court would consider appropriate fairness or need standards for maintenance to be paid. So it's not something that automatically happens in every single case. It's a case by case basis on if one spouse should be awarded any sort of maintenance.
Got it. And is it specific to husbands pay it, wives receive it? I mean, meaning is it gender specific?
No, it's not. It goes both ways. I mean, I see cases where husbands pay it to wives and cases where wives pay it to husbands. Gender is not one of the factors that the court considers when determining if maintenance needs to be paid or not. It's eligible for both genders equally.
And that might be like a misconception, right? Is that you may find from clients that they seem surprised that they have to pay it or that they may be eligible to receive it based on some gender bias or gender stereotypes. What other misconceptions have you seen with clients?
There's lots of misconceptions when it comes to maintenance. I think people a lot of times when they're going through divorces tend to rely on friends or family that have maybe been through divorces when trying to gauge if they're able to have some sort of maintenance awarded to them. And I would say that normally is not a good way to try and base on if your case specifically would be maintenance, just because your friend or family member received maintenance for a certain dollar amount every month doesn't necessarily that's what's going to be happening in your specific case. Every case is so different, and it's going to depend on the specifics of your case, on if maintenance is going to be awarded. And so when people rely on or look at friends and family that have been through this process, they might be set up for disappointment or might have false information. That's why I always say, do not do that. Look at the specifics of your case and talk with an attorney about your specific case.
Yeah, that's a great point. I do think people come in with preconceived notions based on my neighbor, my cousin's friend, what happened in their situation has really no bearing on that individual's case, right? So that's a great point. What about
It like depends on the county too, right? Your friend might have been divorced in Milwaukee County and your case
yes.
might be in Waukesha County or Washington County. And every county, even though it's all Wisconsin, every county has different judges, different protocols of what you see happen with maintenance. So what you see happen in Milwaukee County is probably very different than what you would see in Waukesha County, for example.
Isn't that interesting? Same state laws, counties that literally share a border, and we might see different presumptions on what might happen there. And I mean, and really, how can a client know that, right? They're going to be relying most likely on an attorney to kind of know the court that they're in front of, right?
Yeah, absolutely.
Yeah. So, what about, situations where, somebody may be at fault, right? There's a wrongdoer in the marriage, like marital misconduct, if there is an affair. How does that impact maintenance?
It really doesn't, which I think is surprising to a lot of people. They would think, well, my spouse cheated on me. Why would I have to pay them maintenance? Or maybe there was domestic violence, emotional abuse in the relationship, financial abuse, and there might have to pay maintenance. And why do I have to pay maintenance? Wisconsin's is a no fault state. And so those types of factors aren't typically factors for determining if maintenance should be paid or not be paid, which I know to a lot of people is really surprising to hear.
What about who filed for the divorce, right? Let's say wife filed for the divorce, husband really didn't want the divorce. Now wife is asking husband to pay her maintenance. Does
Yeah.
he have an argument to say, I didn't want this divorce, I shouldn't have to pay?
No, it doesn't matter who wants the divorce. It could be jointly wanted. One party might want the divorce, one might not want it. But regardless of whether you're the party that wants the divorce or not, it doesn't make a difference when awarding maintenance. And that's not something a court would consider or look into, which I think can be really difficult if you're the spouse that doesn't want this and then you're being told you're likely going to have to pay maintenance. It's really difficult to hear.
Yeah, I would imagine that's tough to deliver, almost like an insult to injury situation.
Yeah.
So what factors do influence whether somebody is awarded maintenance?
Yeah, courts consider there's, I don't know, maybe around 10 factors that is in the Wisconsin statute that courts can look at when deciding if maintenance could be awarded. These factors can be the length of marriage, the earning disparity between the parties, earning capacity and education of parties, what the contributions of each party was to the household during the marriage. Were they the parent working? Were they helping the other party, go through school? Was there a stay-at-home parent? They also would look at like the age and health of the parties. Are both parties of working age? Are they healthy? Are they able to work? I would say, although there's not one factor that's listed in the statute that says this is the most important factor to look at. The one we do typically see courts rely on the most would be, or look at the most, the length of the marriage and the earning disparity between the parties. I think across the board, you don't really see short term marriages result in any sort of maintenance or spousal support. Although all of the factors should and can be considered, you do see those two, the length of marriage and earning disparity, weighed on, I would say, the most heavily when awarding maintenance.
Sure. Yeah, and that makes sense, right? If you were married for 1 or 2 years, even if there is an earning disparity, it probably didn't create that partnership that creates the need for it. So, how is the amount of maintenance determined by the court?
And this kind of goes back to it being a gray area. It doesn't say in the statute exactly how maintenance should be calculated. For example, child support's the exact opposite. I mean, you have a formula, you plug in the incomes of both parents, the schedule of the kids, it spits out a number. There's not that same formula for us to rely on when calculating maintenance. It's fairness and need based. So they consider those factors. In some cases, it might be looking at the needs of each party, what their monthly expenses are, how much they need to afford a home to live in, maybe to support their kids, if there's health conditions that are causing them not to be able to work. In other cases, we look at equitable division of the available income. So, for example, the courts would look at what's the net available income available to each party and how do we want to divide that income? Do we want them to each have the same amount of income at the end of every month, resulting in a 50-50 division of income? Do we want it to be a 45-55 division of income? How do we want to divide that? So there's not one way that you see across the board for every case. This really goes back to this being very, very case specific and the specific needs and fairness in that specific case.
Got it. Okay, that's very helpful. What about these situations where one of the spouses is choosing to work part-time? I mean, they're not disabled, they're capable, but they're choosing to either work part-time or maybe even not at all.
Yeah.
Then what?
Yeah. Then it becomes an earning capacity issue. So, what do we feel like that party who's working part time could actually be earning? A court can impute income. So, they can say, even though that's not what you're actually making, we believe you have the ability to be working full time and to be making double what you're making now. And so, when we're looking at support, we're going to impute you to an income. The earning capacity, if an agreement can't be reached on what you feel like one party's earning capacity is, for example, if you can't just both agree, if someone's working part-time, to just calculate their income at 40 hours, if the other party won't agree to that, you would have to bring an expert in and get a vocational evaluation done. So someone from the outside that comes in looks at this person's work history, their education, their health, and what they feel like. This vocational evaluation would determine what they feel like that party's earning capacity is and what they could be earning if they were working full time. And so then you would use the income that the vocational evaluator determines is appropriate for that party. And then you can use that income when looking at those other factors, such as division of income, temporary needs to pay for housing, or other expenses that you have, rather than using their actual part time income.
Very interesting. Okay. And in a divorce, there's minor children and let's use a situation where wife is out earning husband and she's already paying him child support.
Yeah.
Is maintenance off the table then because he's already getting child support?
Not necessarily. It would depend on how much child support's being paid and how it would, the child support that's being paid, we would factor that in as to the income available to now husband if wife's paying husband. So husband's income would be increased. But if there's still a large disparity between the income after wife's paying husband child support, it is possible that there would be a maintenance obligation in addition to the child support payment. Again, that goes back to the earning differences or the earning disparity between the parties. So the child support payment is considered, but just because it's being paid doesn't necessarily mean that there's no maintenance obligation at all.
And would you ever see maintenance in a case where the parties were never actually married? They're long term partners, they live together, they might even have kids together. When they break up, are either of them eligible for maintenance?
No, no, they're not. Child support, yes, if they have kids together and there's paternity established, but not maintenance. No, you have to be married to have maintenance be awarded. I mean, if you're not ever married, you're not actually going through the process of a divorce or a legal separation. So maintenance is not something that would be awarded in those cases.
And is there a way to perfectly protect yourself if you are going to get married and you want to avoid paying maintenance? I mean, could you put that in a prenup?
Yeah. Uh-huh. Parties can put that into a prenup. Whether or not it's enforced long term is a different story. But yes, I think that if you put it into a prenuptial agreement, I think that makes a really, for waiving maintenance. And then your spouse, when you're getting divorced, tries to come and ask for maintenance, the court definitely considers that prenuptial agreement that was in place. Yes.
And is that prenuptial agreement airtight, perfectly enforceable every time?
No, it's not. If circumstances have drastically changed and it would be really unfair to one party to have no maintenance, I mean, maybe you have kids now or one party became ill and they're not able to work, the court could decide that not to uphold the agreement that's in the prenuptial agreement regarding the maintenance waiver.
Interesting. What about taxes? Who's paying the income tax on this money?
The payer. So the person that's receiving the income every month is not, it's tax-free income. If you're getting $1,000 a month in maintenance, that's cash you're getting every single month, tax-free to you. You do not have to claim it as income when you're filing your taxes.
And the person paying it doesn't get to deduct it from their income?
No, they don't.
Ooh, another insult to
Yeah.
injury.
Yeah.
Having to deliver a couple blows to this person that you're having to tell about maintenance.
Yeah, right.
All right. Is a kind of a takeaway here. What advice would you give to someone who's thinking they may be entitled to maintenance or may have to pay maintenance?
Yeah, I would say talk with an attorney who knows your specific county, meet with someone so they can ask you these questions and help you sort through these factors and give you real practical advice on whether or not they think that you do have a maintenance case or could be entitled to maintenance. Because I think if you go in with unrealistic expectations, you might be disappointed, and it might create a process that's maybe a lot longer or more contested than it needs to be. Where if you know upfront, if this isn't a maintenance case, it might help the process go a lot smoother for you.
It's great advice. I mean, it sounds like the overall takeaway here is your case is unique,
Mhm.
and maintenance is really about what is fair and reasonable within your case. What are the needs of each party? It's really not, I mean, I keep saying insult to injury, but it's not a punishment, is it? I mean, it's about this fairness and need concept after a marriage, and not punitive, not because somebody did something right or wrong in a marriage, but really based on the financial positions of each party at the end of the marriage.
Yeah, exactly. Yep.
Very good. Well, this was so helpful. I really appreciate you being with us, Bailey. And I hope that this was helpful to those listening.
Thank you.
Most people walk into divorce court expecting maintenance to make things fair. Well, in Wisconsin, that's not exactly how it works. And the real rules for how much you'll pay or receive might surprise you. Find out exactly how Wisconsin court judges rule on maintenance amounts in this next video.